Suburban Sentinel here, coming to you from ground zero in the war against gun owners, which is of course the state of Connecticut, somewhat ironically known as the Constitution State. This is a video response to the Yankee Marshal's well-deserved criticism of the recent Second Circuit opinion, which upholds the irrational and draconian gun laws within this state. And the purpose of this video is a point of order or clarification on that decision. If you have not read this decision, suffice to say it is an abomination that vitiates our Second Amendment rights under both the federal and state constitutions. Also note, this is not some far-flung hypothetical for us here in Connecticut. The chief mouthpiece for the state police essentially implied in a statement that they are ready, willing, and able to go door to door confiscating weapons. So we do in fact have skin in the game, and many of us are taking precautions, being ready to respond to this scenario. We are all, of course, understandably upset at the outcome of the case. Many people are also very angry at the specific language the court uses in its decision, and that is twofold. First, the judge does in fact recognize that the new law does infringe upon our Second Amendment rights. Second, the judge notes that this infringement is justifiable based on the needs of public safety. Now, of course, many people are absolutely enraged at this. Now, I am in no way agreeing with, condoning, or defending the court, but I do want to say that the judge's language in this context is standard legal mumbo jumbo. So I want to put a finer point on this. All rights, including fundamental or constitutional rights, have limitations. And one of the most popular examples of this is one is not permitted to go into a crowded theater and yell fire and justify those actions based on the First Amendment. So every right, no matter what it is, has some sort of limitation, whether it's mentioned in the Constitution, in the statutes, or not. So let's take a look at this particular situation. The court is examining a fundamental right, a Second Amendment right under both the federal and the state constitutions. In judging the constitutionality of a law and or its application involving a fundamental or constitutional right, American courts are bound to use what's known as strict scrutiny. And that strict scrutiny means that the state or federal interest must be compelling. It can't be some willy-nilly whim. It has to be a highly compelling interest, and the law must be narrowly tailored to serve that interest. So in my opinion, I believe the court in this case is using the proper standard, using strict scrutiny, and using the proper language. My problem, as with many others, is that the analysis itself is just off the wall. The Connecticut gun laws in question do certain things such as banning entire classes of weapons based on their appearance, require the registration with the state of certain weapons, and bans the use and even ownership of normal capacity magazines. Now, not only do these new laws not serve a compelling public interest, they serve no interest at all. That is the problem. It's not the language of the decision. It's the application that's a huge issue for those of us in Connecticut and throughout the nation. Why is any of this important? Well, I believe that in this fight we need to maintain focus. The language used by the court is, in my opinion, a distraction. Let's keep our attention where it belongs, on the merits of the case. Thanks for watching. This is the Suburban Sentinel. Please thumbs up and subscribe if you like what you see. Questions and enlightening comments are always welcome. Our fight is your fight, and we here in Connecticut will not give in and will not give up. Peace, everybody.